is Doug Dean. I'm the owner and managing partner at Schaefertz and Dean. Our Business Builder Speaker Series was an idea born out of the COVID days in 2020. When we couldn't get together in person, we said, let's get together virtually once a month. We'll bring on a speaker with with a topic that we think is important and valuable to the real estate agent community that we serve. We do it the third Wednesday every month at 10 o'clock with tips and tricks that will help your real estate business grow. We know that you're busy. We appreciate you joining us and giving your time. And to make the most of your time, we encourage you to ask questions. The easiest way to do that is just throw those in the chat box, and I'll grab those as we go through. If you've missed prior episodes, we record each month's Business Builder speaker series. We post it to our YouTube channel, and we link to it on our website. Additionally, we invite you to join us by following us at all of our socials. This month, these are our first two, January and February, but on our website under the resources, you'll find our library of Business Builder Speaker Series, and we have about 48 or 49 videos there on a variety of different topics. Mark your calendar for next month. Next month will be March 19th is the third Wednesday at 10 a.m. Our speaker will be Essie Selander, The Psychology of the Close, using a disc for top producing realtors. And it's about understanding some basic human concepts and basic psychology to help you connect with people and grow your real estate business. This month, yours truly, Doug Dean, will be teaching Don't Let the 2026 GAR form changes bite you. And what I'll be doing is I teach a 3-hour CE class on the 2026 GAR changes, GAR contract changes. And what I've done is I've taken all the high points out and I've distilled it down to a 1-hour class. And that's what we'll cover today. I'm going to go ahead and switch my screen share to our presentation, and we'll go ahead and jump into the material. Our class today is an overview of 2026 form changes. What our class is a helpful 1-hour overview of important 2026 GAR form changes. What our class isn't is offered for CE credit. There's no CE credits. It's only a 1-hour class, and it's not a substitute for legal advice and your own research. It is good information, and I encourage you to follow along and watch and learn. I want to begin the presentation by thanking Mike Nelson, who's the broker at Excalibur Homes. Mike taught a class called the Train the Trainer. Each year, when GAR changes their contract forms, they have a class where their people teach people like myself who teach GAR forms. And we had his permission to reuse the slides he used from Train the Trainer for our GAR contract changes class. Each year, January 1st, GAR makes an annual revision to the GAR forms, and they do so for two reasons. One is changes in the market, what has happened in our industry, things like the Burnett lawsuit and how we disclose commissions, which we now call compensation instead of commissions. The other thing they do is they take into account what's happened in the court system. Is there anything in the court system that our forms need to be revised to address? One thing GAR does a very nice job of, and you're looking at the 2026 GAR forms changes, is they go form by form, paragraph by paragraph, and tell you exactly what changed. So the index of GAR form changes is available wherever you access your forms. For 2026, we have 6 new forms, 1 new special stipulation, and 1 special stipulation that was deleted. The new forms are the 105, the exclusive co-listing seller brokerage engagement, and we'll talk about that one. It is a way for agents of two different brokerages to work together and to be the listing agent on a property. 331 is an unsafe property disclosure. 334 is a disclosure to buyers who insist on buying property sight unseen. 528 is a holder's notice to all parties about earnest money, and we'll touch on that. One thing GAR does a nice job as well is that the form numbers years ago, they didn't mean anything. Several years ago, GAR renumbered all of the forms so that the form number gives you a clue as to what it is. F is form, CF is commercial form, and the first digit of the three numbers for the GAR forms, the 100 are brokerage engagements, 300 series are disclosures, 200 series forms are purchase and sale agreements. The 900 series are lease agreements. So just to look at the form number, you have an idea of what type of form it is. CFO2 is the commercial tenant buyer brokerage agreement, and CF13 is an exhibit to the commercial purchase and sale agreement. The special stipulation that was eliminated was number 110, no commission owed by the buyer. And the reason it was removed is because it was no longer relevant. The way that we disclose compensation has changed with buyer brokerage agreements, so we no longer needed that special stipulation. The new special stipulation is 333, entitled Walkthrough List. You'll see it when we get there, but its purpose is to protect a buyer who's buying new construction in a jurisdiction that doesn't issue a certificate of occupancy. And what it says is that if at walkthrough, the cost of finishing items on the walkthrough list exceeds $5,000, the buyer can postpone the closing. Another nice thing that GAR does is universal changes. What are they? GAR uses standard language throughout all the forms. The words, terms, and phrases have the same meaning everywhere throughout the GAR forms. When a change is made to one of those items, the exact same change is made on all GAR forms where that word or concept appears, and those are called universal changes. Once you learn what that change is, you'll see that exact same change populate across all forms. Sometimes you'll see, oh my gosh, there's 20 changes. But when you look carefully, it's one change that appears on 20 different forms. Once you learn it once, you got it for all 20 forms. So some of our universal changes this year, one dealt with statute of limitations. Everywhere there's a form that references a statute of limitations, it was changed from 2 years to 1 year. And that was based on a court case last year that upheld a 1 year statute of limitations. So GAR said we will adopt a 1 year statute of limitations. The word commission changed to compensation throughout. The word paying is changed to offering. All terms that are defined in a GAR form are now capitalized. There's legal significance to using the capitalized version of the word. For example, when you use banking days and it's capitalized, you know that term banking days is defined in the form, so we know we're using banking days as it's defined. The word notices is now notice. We modified the date fields to make them consistent across all the forms. Previously, we had the date form in about 4 different formats, and we've tried to make it standardized. A universal change regarding the protected period in brokerage and customer agreements. A change in the seller's warranty of title in the purchase and sale agreements and option agreement. A universal change regarding the right to extend the closing date, the 8-day unilateral. A universal change regarding holder of earnest money in the purchase and sale contracts, and in the agency disclosure in the purchase and sale agreements. Another universal change is the disclaimer. I'm often asked, are GAR forms written to protect buyers or sellers? And I tell people, neither. GAR forms are written by attorneys who represent the Realtors Association, and they are written to protect licensees and brokers. And the disclaimer language, when we get there, you'll see how that benefits licensees and brokers. The entire agreement language is a universal change. The entire agreement language basically says whatever a buyer and seller talked about during the negotiations, none of that matters. What matters is what we've reduced to a writing in the contract. Property delivered in a clean condition, two minor changes there. Instructions to seller in completing a seller's property disclosure, and how a buyer should use a seller's property disclosure. Some universal changes regarding financing contingency, financing exhibits, nothing too dramatic. The special approval for properties that have a master insurance policy, typically condominiums, but some townhomes might have a master insurance policy that protects the building exteriors. Essentially, what we've adopted is a belief that if you can't get a loan because the association lacks the proper type of insurance, the buyer shouldn't be forced to buy the property or lose their earnest money. And you'll see that when we get there. Use of approved lender and loan denial letter, a couple of minor changes there, and the right of the seller to request evidence of the buyer's ability to close the loan and the financing, and we'll cover that when we get there. So moving on to our first one, F101, the exclusive brokerage engagement, there's a minor change highlighted in blue. Its purpose is to add language that virtual showings count for finding a buyer you're protected with the protected period. In the 104 non-exclusive brokerage agreement, it looks like a lot of changes. There's a lot of blue, but mostly we clarified wording and we added that you must show the buyer either in person or virtually to get protection under the protected period. Just giving out information doesn't meet the definition of the protected period for the non-exclusive brokerage agreement. The 107, the authorization to show unlisted property, we added language to clarify the terminology, and we eliminated some language that really didn't belong there in the first place. When attorneys draft a form, they always start with another form that's similar, and then they modify it to serve the purpose of the new form. And sometimes you forget to make some changes. The struck through language, for example, when you're working with authorization to show unlisted property, you're working with the owner, not a client. So it mostly clarified the language and eliminated some language that didn't belong in the form. In the 110, 113, and 116, we added language about the protected period and mostly just clarified the language. Moving on to the purchase and sale agreements, and you'll see a list of all the purchase and sale agreements. It doesn't show F201, our standard purchase and sale agreement, but that is a typographical error. This is also in the F201 purchase and sale agreement. Basically, the seller warrants good title. The seller warrants that there are no survey encroachments, with a few exceptions. And the exceptions previously were driveway and walkway. We added wall, fence, and mailbox. And the reason we've added those is because we ran into a lot of situations where those were built properly at the property line. And over time, they tend to sag and lean so that they become a survey violation, even though they were originally built in the correct location. So we added those to the list of exclusions. If you have a wall, fence, or mailbox that sags over the property line, it isn't a violation the seller has to cure. Our 8-day unilateral extension, we made a lot of changes here. The idea with the 8-day unilateral extension is if the buyer or seller is not ready at the time of closing and there's a good reason for it, they can give notice to the other party and say, I want to extend the agreement for 8 days. The buyer can use it for a mortgage lender delay not caused by the buyer. For example, if the lender says, I'm not ready because the buyer didn't give me tax returns, the buyer's not protected. But if it's a lender delay not caused by the buyer or an attorney delay not caused by the buyer can send notice and get an 8-day unilateral extension. Likewise, the seller can use 8-day unilateral if there's some type of title delay that can't be fixed just by paying money. For example, if you have a materialman's lien, that will go away at closing if you just pay the lien. So that doesn't protect the seller. But if there's a title delay where we need a corrective deed or something, then the seller can use the 8-day unilateral. The buyer and seller can only use the unilateral one time each per contract, with one exception. If one side has already used closing attorney delay as a reason for a unilateral extension, it may not be the basis for an extension by the other party. And anytime a party wants to use an 8-day unilateral extension, they do so by notice to the other party. And this is the language in our GAR forms. Each of the forms listed here have the same language about the 8-day unilateral extension. We made a minor change regarding the holder of earnest money, really two changes. One is we had a broker listed as the holder of earnest money who didn't want to fulfill their duties. They said, I have a party as a client, and it's therefore a conflict for me to fulfill the duties as holder of earnest money. And GAR said, we disagree. Even if you have a client, you still must perform the duties of the holder of the earnest money, even though you represent the parties. We also added a requirement that earnest money would come from an account drawn in the U.S., a U.S. bank. We made a change in our purchase and sale agreements regarding agency disclosure. What we clarified is that no broker owes a fiduciary duty to the buyer and seller. And this was a reminder that under BRETA, agents in Georgia act as intermediaries with defined responsibilities, not traditional fiduciary duties. The disclaimer language is here for two reasons. One is licensees tell buyers and sellers you might need the assistance of any one of a number of professionals, architects, attorneys, accountants, tax planners, structural engineers, pest inspectors, surveyors, and that's outside the scope of the service that you offer as a real estate agent. The second thing we've clarified is that if you provide information to a party and that information is later determined to be inaccurate, you're not liable if you didn't know it was inaccurate and you tell people the source of the information. For example, if your seller tells you the rear property line runs along the stream, and the buyer asks you, where does the rear property line? And you say, the seller informed me that the rear property line runs along the stream. If it's later determined that that's not where the rear property line is, the seller may have liability for the misrepresentation, but because you didn't know it was inaccurate and you quoted the source of the information, you're not liable. We added promises, statements, and referenced other sources of reference and extended it to the amendments. But that's what we were trying to cover in the disclaimer section. In the entire agreement section, I touched on it earlier, that the entire agreement language says buyer and seller may have discussed a lot of different terms in the negotiations, but at the end of the day, the only thing that is enforceable is what is in writing in the contract. And that's the concept of the entire agreement language. There is a small typo in the word referenced that'll get fixed if it hasn't been already by GAR in the forms. The property to be delivered in a clean condition. This was already in the GAR forms, the purchase and sale agreements. The change that we made is we added the word construction materials, that the seller will deliver the property free of trash, garbage, debris, and construction materials. And the reason that's relevant is a lot of well-meaning sellers want to leave leftover supplies. They have extra paint from when they repainted the house, and they'd like to leave cans of paint for the buyer. One buyer got upset because he had to pay to dispose of all the paint cans. So we added construction materials. The takeaway is if you have a seller who wants to leave things in good faith for the buyer, get agreement with the buyer that they do or do not want the paint cans, the leftover shingles, the leftover window screens, whatever they might have. Otherwise, the buyer can say those are construction materials and the seller should have removed them. We also added that if the seller has a stack of firewood in the yard, firewood is not considered debris. The seller can leave stacks of firewood on the property. The instructions to seller for completing the seller's property disclosure, just minor changes to the wording, trying to make it easier to read. For example, in the number one, the word thereon was changed to on the property. Instead of improvements thereon, it's improvements on the property. So just minor wording changes to simplify the language. In the how this statement should be used by the buyer, I think GAR has done a nice job of setting an expectation to the buyer. If the seller says no on a property disclosure item, that's not a warranty or guarantee. It just means the seller has no reason to believe the condition exists. And it is for that reason, it's similar to I don't know. In other words, if the seller says there are no termites, the seller has no knowledge of termites, but it doesn't mean that condition doesn't exist. If that's important to the buyer, they shouldn't rely on the no answer and they should get their own pest inspection. In the financing contingency forms, one of the requirements is that the buyer must produce a loan denial letter. That's always been the case, but we added the loan denial letter must state the basis for the loan denial. Why was the buyer denied the loan? That's important because some reasons that the buyer might be denied the loan don't protect the buyer. For example, the buyer was denied the loan because he never provided pay stubs, tax returns, and other requested information. Well, the buyer's not protected in the financing contingency if he doesn't diligently pursue the loan. So that's why we added basis for loan denial. It seems obvious, but we do need the reason on the loan denial letter. We added this language as special approval if the property is in a condominium or other property that's subject to a master insurance policy. If it doesn't have the right kind of insurance, the buyer doesn't have to buy it or lose their earnest money. And the only change is we changed the wording from time of closing to date of closing. And the reason we did that is because the buyer and seller might sign at different times, but it's really the date of closing. If the property lacks the appropriate insurance as of the date of closing, the buyer can terminate and get their earnest money back. The use of approved lender and loan denial letters in the four financing contingencies, again, the wording is there that must state the basis for the loan denial on the loan denial letter. The right of the seller to request evidence of the buyer's ability to close. Once we get past the end of the financing contingency, the seller has the right to ask the buyer, will you be able to get this loan? Will you be able to close? And what we did is we adjusted the time frames to try to prevent a request that runs past the closing date. We basically said the seller can't make this request less than 5 days before closing. And if the seller requests evidence that the buyer can get the loan, he has 5 days to do so. And if he doesn't, the seller, he gets a 2-day right to cure that, 2 more days to produce it. Otherwise, the seller has the right to terminate. But in addition to the 2 days, we said, or however many days are left until closing. If there's only 1 day left till closing, he only gets one additional day. A quick word about consumer brochures. GAR put together a lot of consumer brochures that are very informational. You should be familiar with them, and you should give these out like hotcakes, as the expression goes. For example, if you represent a seller, automatically send them the consumer brochure, Protect Yourself When Selling a Home. That way, if the seller has an issue or a problem and they later allege it's your fault, and you say, I provided a brochure, Protect Yourself When Selling a Home, and it addresses that. The changes we made in the consumer brochures and Consumer Brochure 19, Protect Yourself When Buying a Home and a Condo, it's just a minor clerical error. It had some construction language that didn't belong. And in Consumer Brochure 31, What New Landlords Needed to Know, we added a paragraph about the importance of insuring the property while vacant. This is the change to Consumer Brochure 19 about a condominium, where we eliminated language that really didn't apply. This is Consumer Brochure 31, where we told landlords to be aware that most homeowners insurance only covers the property for 30 days of vacancy. Some policies go up to 60 days of vacancy. But if you're a landlord, you need to know how much vacancy does your policy cover. And if the property will be vacant longer than that time period, that you might need a different type of insurance policy to cover the vacancy period. The seller brokerage agreements, there's a list here, paragraph by paragraph, of the changes. Most of the changes were designed to be consistent with the NAR settlement, the NAR changes, and a lot of these are important more so in other parts of Georgia than Metro Atlanta. But remember that the FMLS and Georgia MLS and Metro Atlanta are independent and they have their own rules and policies that you need to follow as well. And this dealt with a change to the wording for marketing through the MLSs, where you identify what MLSs the property will be listed in. And we caution the seller that using less than all available can limit the number of offers you receive. And we reworded the language about coming soon, immediate marketing, delayed marketing, office exclusive, and we added a disclaimer that anything you do that limits the number of potential buyers can reduce the number of offers and the purchase price that you receive. So this change is in the 101 exclusive seller brokerage agreement. In the exclusive seller brokerage, we had a consent of the seller to be called. If the seller's on a do not call list, they do allow the licensee and the broker to call them. In both the 101 exclusive and 104 non-exclusive, we added language. The idea here is once compensation is established by the seller, and let's use an example. The seller said, I agree to pay compensation of 6%, and that is to be shared equally by the two brokers. But for whatever reason, the buyer's broker requests no commission or requests less than what was offered. What happens to the difference? The language reads, the difference goes to the listing broker. If the buyer's broker only requested 2%, then the listing broker gets 4%. The seller still pays the total that they've agreed, and that's how the split is adjusted. Now, an important change this year, a new form was 105. This is an exclusive co-listing seller brokerage engagement. And the idea here is it allows agents of two different brokers to work together to list a property. And one area where that might be most helpful is when the property is geographically in an area that one broker just can't serve well. And one option would be just make a referral. But your seller says, I like you, I want to work with you, even though it's in another area. And you say, I can co-list the property with an agent, a broker in the other area who has access to the MLS and is closer to the property. So that's the idea with the new form. Most of the 105 is designed to mirror the 101, the exclusive seller brokerage agreement. So they really track pretty well together. I've noted the differences between the 101 and the 105. Also, this is a new form and a new concept. Check with your broker policy to make sure your broker allows this. This is the top of the 105 co-listing brokerage agreement where we identify broker one and broker two. We identify what is the total compensation the seller is paying to the seller's brokers and how that is going to be split between the two of them. Is it an equal split or a 75-25? Now, that is strictly between the two brokers, not the total compensation. The compensation to the buyer's broker is listed separately. We added a paragraph for separate compensation would be due on a lease if the seller decides to lease the property instead of selling it. We added a chart for how we're going to break up the division of labor. And we go several pages listing all the services that a listing broker provides and identifying is that going to be done by broker one, by broker two, by both of them, or it could be either one of them. And we'll go through and fill out that chart for all the services that'll be provided. Then we get to the signature page where we have signatures for both broker one and broker two. There's a typo in the word licensee that they'll correct. Again, it's up to broker policy if your broker will allow you to use a seller co-listing agreement. And secondly, some brokers do allow it, but their requirement is that the broker signs the form. They want to be aware of it and review it instead of having the agent sign the agreement for them. A minor change in 107 was just the authorization to show unlisted property. First, we added language for the protected period. And secondly, we moved the fair housing disclosure language down to paragraph 21. The buyer brokerage agreements, similar changes to the protected period, but we added one more important thing. We talked about how GAR forms are designed to limit liability of licensees and brokers, and we added language to say the limitation of liability survives termination of the agreement. Generally speaking, parties' obligations to each other end when the agreement ends. But there are things that we identify and say this should be a continuing obligation even after the agreement ends. And we said, the seller's limitation of liability to the licensee should extend past termination of the agreement. In the 116, working with buyer as a customer, we added language to clarify the compensation is due at the closing of the property. And we removed some language again that really shouldn't have been in the form that wasn't relevant to the agreement to work with buyer as a customer. F-128 is a leasing and management agreement, and the only real change here is we changed the formatting. This one had the old formatting where it was a series of numbered paragraphs from paragraph 1 through 48, and we put it in the ABC format, just like we have the F-201, the purchase and sale agreement. All the key terms that have fill in the blanks are in section A. Section B is the details that explain each section in paragraph A, and paragraph C is further details about the agreement. So this one, 128, was a laundry list of paragraphs, and each paragraph got put into that ABC format. We reformatted with paragraph A being key terms and conditions, and paragraph B being the corresponding explanation for each part of paragraph A. Throughout, commission was changed to compensation. We added language that the property manager can now approve applicants if the owner doesn't respond timely within so many days. We added language to allow for automatic renewals, and we adjusted the automatic renewal language to comply with a new state law that was passed last year. And we added paragraph to clarify when a monthly fee for serving as escrow agent applies. Management fee is a percent of the amount collected. We added landlord agency to the list of agency types. We strengthened the indemnity language, and we added authorization for the manager to use automatic and AI-generated messages to tenants. What's interesting is that is the first GAR form that has addressed use of AI-generated messaging. And I think we're going to see that appear in more GAR forms over time. In our purchase and sale agreements, they all had similar changes, all universal changes, all of which we covered earlier. The warranty, the 8-day unilateral, the broker's responsibility as holder of the earnest money, even though they have a client, the agency disclosure that they don't have a fiduciary relationship, the disclaimer language, the entire agreement, and the property delivered in a clean condition. We touched on all of those earlier. There is one more change in our purchase and sale agreements, and that was on the new construction side. Generally speaking, we know that our GAR contracts stipulate if the buyer breaches the agreement, the seller gets to keep the earnest money. But what about construction deposits on a construction purchase and sale? And we clarified that if the buyer breaches the agreement, the buyer forfeits both earnest money and construction deposits to the seller. The 249 counteroffer and 290 agreement to reinstate, just some minor changes here. In the 249 counteroffer, in the counteroffer, the buyer makes an offer on a purchase and sale agreement, and the seller can either sign it and accept it, or the seller can send back a counteroffer that says, I agree to everything in your purchase and sale agreement with the following changes. And then the buyer and seller both sign the counteroffer, but they never both sign the original purchase and sale agreement and the exhibits. And that always bothers our lenders. They say, why didn't the seller sign the purchase and sale agreement? And the answer is because they signed the counteroffer, which incorporates the purchase and sale agreement. So we added language here to clarify for our lenders' benefit that the counteroffer being signed creates a legally binding agreement, even though other parts of the agreement are not signed and initialed. And if we do a conformed or clean copy of the agreement, where we say, let's just take a blank purchase and sale agreement and let's write all the terms that we've agreed to and sign that, we add the special stipulation that says this is a conformed copy of the agreement and the original agreement still controls. But what we added here in blue is we use all the dates from the counteroffer, not the date that we are signing the conformed or clean copy of the agreement. So that just clarified the language. And the pre-showing compensation agreement, we changed the date, just standardized the date format. The 290, the agreement to reinstate the contract, we added a line that says the offer to reinstate an agreement has an expiration date, so it isn't open-ended. If we have a situation where the property has accidentally fallen out of contract, meaning we've gone past the closing date, but the buyer and seller both still want to buy and sell the property on those terms, we can use a 290 to agree to reinstate the contract. But whoever makes the offer to reinstate it, now paragraph 5 says there's a time limit on this offer, so it isn't open-ended. They have to sign it by a certain time. There's mostly wording and minor changes in the seller's property disclosures. I'm going to go fairly quickly through them, but we do record it and we will send you a link to the video so you'll be able to pause it and review in more detail any of the language that you'd like to read. One of the things we added in the seller's property disclosure is propane and fuel tanks. Advise the buyer if that condition exists. We revised the wording about septic system. It previously said local government authorities, and it now reads health department or other government authorities. Some fairly significant changes about water intrusion, excluding water intrusion by plumbing. Have you had water intrusion into the property, i.e. a flood? Have you had a claim under the flood policy? Is it a repetitive loss? Is it in the floodplains? So there's some changes here to the water intrusion section of the seller's property disclosure. F302, a seller's disclosure of latent defects. Georgia is what we call caveat emptor, or buyer beware. That means the only thing the seller is legally obligated to disclose to a buyer is hidden defects, material defects, that the buyer couldn't discover by reasonable due diligence. The seller doesn't have to disclose a hole in the roof. A buyer could see that with reasonable due diligence. The seller does have to disclose a roof leak that doesn't have visible evidence of it. It's hidden material damage that the buyer couldn't find by reasonable due diligence. So we've added language about caveat emptor, buyer beware, and that the buyer can't modify this disclosure. This is the minimum that the seller is required to disclose. Some minor changes into the lead-based paint exhibits. We had a note to brokers to consider a policy to always have buyer and seller agents initial the lead-based paint disclosure on all contracts where it's included, just as good policy. In the 316, the agent acknowledgement, we added the wording federal law, and we indicated the buyer's agent is obligated to inform the seller of lead-based paint obligations if the buyer's agent is paid either directly or indirectly through a cooperative brokerage agreement. If the buyer's broker is only compensated by the buyer's broker or by the buyer, this buyer's broker doesn't have an obligation to inform the seller of their lead-based paint obligations. So if the buyer's broker is compensated either by the seller directly or by the seller's broker in a co-op, the buyer's agent needs to initial. And a reminder, 317 was a new form in 2025, and this is a buyer broker notice to seller of seller's obligations regarding lead-based paint. The seller typically doesn't have to complete a form like this because it's already contained in the 101, the exclusive seller brokerage agreement already contains the seller's notice to seller broker notice to the seller. But if you're a buyer broker who's being compensated by the seller directly or indirectly, you should use the 317 and give the seller the notice of lead-based paint. A lot of changes in the community association disclosure, but the key fundamentals of the community association disclosure remain the same. First, we go into details about completing the form, about the seller's obligation to complete the forms accurately, and that the seller will be liable if the amount the buyer has to pay is more than what the seller disclosed. We also added that the seller has a continuing obligation to let the buyer know if the amounts change. If the seller learns that there's a cost increase in the association, the seller has to tell the buyer, and also that the seller's obligation is based on the original disclosure, not the updated disclosure. So if the HOA dues went up from 500 a year to 600 a year, the seller has to tell the buyer that, and the seller is liable for the increase. The seller must update the disclosure if new info is learned before closing, and the seller must pay the difference between what was disclosed and the actual fees, and the difference is based on what the seller initially disclosed, not on the updates. Here we clarified the different types of associations that a buyer might have to join. And we also let the buyer know HOA fees can and do change over time. Just because we have it right at time of closing, after you buy it, your dues can go up, and you as a buyer need to be aware of that. Here we reworded the title. What are association dues? They are annual regular assessments, and we listed that they might be due for both the association and for a master association. So we have those split out and correctly labeled and itemized. We go on to say that the buyer will pay whatever accurately disclosed association dues are due, and that the seller will pay to the association any dues that are over what was disclosed. If the seller disclosed a $500 initiation fee and the initiation fee is $600, the buyer will have to pay $500, but the seller will have to pay $100 of the initiation fee because that's more than was disclosed. The section on the account statement or clearance letter is still there. It was just moved to a different section. We added wording. First, we capitalized special assessments because that term is defined elsewhere in the agreement. So that is what we call a term of art. And we clarified that if the special assessments are changed from when the buyer goes under contract before closing, and they're changed to an amount that exceeds the amount of the dues, that the buyer has termination rights. If the buyer finds that the special assessments are going up, the buyer has the right to terminate. Um, just a wording change here that the one thing they did to clarify here is sometimes it's unclear. Is this a buyer fee or a seller fee? And we've clarified that all fees are going to be what the HOA says they are. If the HOA says this is a seller fee, it's a seller fee. If the HOA says it's a buyer fee, it's a buyer fee. The other thing that the last isn't a change, but the transfer initiation admin fees paid by the seller, if they're over and above what was disclosed, are considered seller fees, and they're not a seller concession or a contribution to the buyer's cost to close. And we added the other association expenses that the seller is obligated to pay the cost of an HOA letter needed for closing, and that move-in and move-out fees are not transfer initiation and admin fees, and those will be paid as directed by the association. A quick word on two new forms. A 331 is an unsafe property disclosure, and a 334 is buying property sight unseen. And we recommend the 331, especially if you're working with investors or you're showing fixer-uppers, and always if the seller's agent has told you about some hazardous issue. If you're told, don't use the back steps off the kitchen because they need repaired, you need to let your buyer know that, and you do that on the 331. So the 331, you would complete it based on anything that the seller or the seller's agent told you to give the buyer notice of unsafe conditions. Now, in 2025, we had two new forms that were somewhat similar. 846 and 847 were a visitor sign-in sheet and a visitor sign-in sheet for viewing a house under construction. And although they sound like sign-in sheets, they also contain language that by signing in to view the house, that you agree to be responsible for your own safety and look for unsafe conditions, things like that. The 331 is similar, but it's for the buyer's agent to have the buyer sign for known unsafe conditions. And that's just a sample of the 846 and the 847, which were new forms last year. And you'll see the bottom of each is the sign in, and the top is the be careful of your own safety language. The 334 is buying a property sight unseen. If you have a buyer who insists on buying a property sight unseen, you need to ask them to sign the disclosure and waiver that says you really don't know what a property is like until you've seen it in person. And I don't want you to buy this property and be disappointed and upset. You understand the risks and you insist on buying a property sight unseen. The financing contingencies all have similar language that we'll cover here in a moment. One of the changes is it a sales price or a purchase price? And I guess that depends on perspective. If you're a seller, it's a sales price. If you're a buyer, it's a purchase price. At the end of the day, they mean the same thing. But in the mid-year, they changed amendment to sales price, ATSP, to an amendment to purchase price, ATPP. And we have the special approval if the property is subject to a master insurance policy, that if a buyer can't get a loan due to it not having the proper insurance, that the buyer can terminate and get their earnest money back. And that right extends up through the date of closing. Now we've added that to the 401 no financing contingency. Even if our buyer is an all cash buyer, if he finds that it lacks the right kind of insurance, so that a buyer can't get a loan, even a cash buyer has the right to terminate for that reason. And that language was already in the other financing contingencies, but we added it to the no financing contingency. And again, amendment to sales price is now amendment to purchase price throughout. 510, the closing attorney acting as holder of earnest money. If you list a closing attorney by name instead of firm, we mean the firm that the closing attorney works for will hold the earnest money, not the attorney individually. We have a new form, a 528, which is designed to help brokers who are holding earnest money. If you hold earnest money, you have certain obligations under the contract. And the form allows the seller to check the box to send notice. And you might need to use the form more than once. First, to advise all parties that the buyer didn't timely pay the earnest money, or that the buyer did timely pay the earnest money, but it was returned. And then the buyer has a cure period. And then you would send the notice again if the buyer failed to cure the default after notice. And you'll see that on the form. The top two check marks are the buyer failed to timely pay the earnest money, and the buyer has the right to cure in 3 banking days. Or the buyer did pay the earnest money, but the check was returned or dishonored, and the buyer has 3 banking days to cure. And then the last check mark after 3 banking days, if the buyer hasn't cured, we give the seller notice of that, and the seller has the right to terminate at that point. They have to terminate within 7 days for that reason. The sale or lease contingency just says that if the buyer's offer is contingent on selling another property and the sale of the other property does not conclude by the date of closing, this contract automatically terminates and the buyer is entitled to a refund of their earnest money. And then there's another section. If there was an existing pending contract at the time that we entered this contract, if that contract falls through before closing, the buyer has two options. They can say, my other sale fell through. I want to terminate this agreement. Or the buyer has the right to eliminate that condition and say, the other sale fell through. I want to eliminate that requirement and I'm still under contract to buy it. Another interesting thing, the word will was changed to shall. And I would have thought will and shall meant the same thing, but the Supreme Court said shall is a command and will means that something will happen in the future. So when it says shall, that means you have right now, not in the future. If the seller wants to give a kickout notice to the buyer has, because the seller has gotten another offer that doesn't contain the sale of other property contingency, the buyer has two options. Say, that's fine, I'll withdraw my offer, you can take the other. Or the buyer can say, I'll remove the contingency. But the buyer also has the right to waive the sale of other property contingency at any time if they elect to do that. Proof of funds that we just changed the terminology from proof of funds to proof of ability to close. And the last section deals with lease forms. This is an F907, owner's property disclosure on a lease. And because it's a 900 series form, I know that it's related to leasing. All the changes here pretty much mirrored what we already covered in the 301. They did add one about water heaters. There's the language about septic, health department, and other government authorities. And have you had damage from a frozen water line, spigot, or fixture? Changes to the disclosure about water intrusion, again matching what we saw in the 301 property disclosure. Have you, as a seller, received notice of any environmentally hazardous substances on the property? The residential lease, we added a charge if if the tenant fails to put a utility bill in their name, the landlord can pay the utility bill and can add it to the tenant's bill along with a fee for paying the bill. The section on utility connection charges was deleted. The security deposit, that utility charges from the tenant not immediately transferring the property into the tenant's name can be deducted from the security deposit. And that if the tenant fails to transfer utilities into the tenant's name immediately after the lease within 1 business day, the tenant is technically in default and the landlord would have rights under the agreement. There's a section for administrative fee. It used to read before the commencement of occupancy. Now it can be paid at any time. The concept of holding over is that the tenant has remained in the property after the expiration of the lease. They are holding over. And we have called the additional money due from holding over is rent. additional rent for holding over, so the landlord can evict if the tenant doesn't pay the holding over rent. In lead-based paint, we just updated the website. There was a EPA website that was now inaccurate, and we corrected it. In the lease, we added under rules and regulations that the buyer can't put, or excuse me, tenant can't put items on the property that the landlord believes are hazardous. It previously said trampoline and above ground swimming pool. It now includes hot tub, tree house, swing set, bounce house, or zip line. It also says that the tenant may not keep any animals, including those listed or any other that are not on the pet exhibit, and that they can't have fires within 50 feet of the structure, of any structure, including storage buildings. This was the section that the property manager may use automated and AI-driven communications to communicate with the tenant. This is the first time we've had language like this in the GAR forms, and we will probably see language like this in the future in more GAR forms. CF2 is a commercial tenant buyer brokerage agreement. It's not yet in the ABC format. It's in the list of subsequently or successively numbered paragraphs, but the form is useful if a commercial tenant decides to go ahead and buy the property that they've been renting. It's a 6-page form, and I just have page 1 as a sample, and that's the case where you would want to use it. CF4, the commercial purchase and sale, all those changes we included when we covered the purchase and sale agreements. The 8-day unilateral, the holder of earnest money, the entire agreement, and so forth. We added language in the CF4, the commercial purchase and sale, that if the seller gets the earnest money, the holder may require a W-9. This language was already in the residential purchase and sale agreements. We just added it to the commercial purchase and sale agreement. CF13 is a commercial purchase and sale agreement, Exhibit B4, and it's just a new list of items to consider in due diligence for a commercial purchase and sale. So you can use that where that's applicable. CF22 is Exhibit D to the commercial purchase and sale, and we just added additional items to check as applicable. For the exclusive commercial leasing agreement, CF24, we corrected the wording. We had seller, but it's really owners on a lease. So just a wording change from seller to owner. The special stipulations, we talked about deleting 110 because the way we disclose buyer compensation to their agent differently, we no longer needed the 110. And the special stip 333, the walkthrough list, said if the property's in a jurisdiction that doesn't issue a CO, and this is new construction, the buyer can refuse to close if the cost to complete the items on the walkthrough list are reasonably estimated by the seller. It should be more to cost more than $5,000 to complete. That gives the buyer the right to delay the closing. 528, the special approval if the property is subject to a condominium subject to master insurance. That is also contained in the financing contingency. And I realize we're just a few minutes past 11. I wanted to keep it to an hour, but we've only got 5 slides left, so we'll be through in just a moment. We've covered all of the 2026 contract changes that I wanted to go over with you in our 1-hour tour of 2026 contract changes. The last few slides are some 2025 mid-year changes. These were made middle of 2025, and I included them because they're still applicable, and I think they're important and they're relevant. The 2025 mid-year changes from June 1st of 2025 You can find a list of what changed at the mid-year 2025 wherever you access your GAR forms. Here, we added the limitation of broker's liability that no broker is liable for providing information that's later inaccurate. If the broker did not have actual knowledge it was inaccurate, and they disclosed the source of the information. We also added that liability limitation, excuse me, survives termination of the agreement. Another mid-year change is that we changed the title closing costs to seller's monetary contribution to buyer's cost. So we don't call it closing cost, we call it seller's monetary contribution to buyer's cost. And what that does is it prevents fighting about whether or not something is a closing cost. It doesn't matter under a definition whether it is or isn't. This is money that the seller gave the buyer towards whatever buyer cost the lender will allow. We added what I thought was a very important change. It used to be that if the buyer didn't pay earnest money, the seller's only remedy was to terminate the contract. But now we added a paragraph under the seller's remedy in the event of the buyer default that says unless the seller otherwise agreed to terminate the agreement, after terminating, the seller can sue the buyer for any earnest money that was not paid, returned for insufficient, or stopped. So what we did is kind of took away a loophole that a buyer who signed a contract and never paid earnest money didn't have anything to lose. Now the buyer is liable to the seller for the earnest money, even if they haven't paid it. So a little more protection there for sellers. Delays caused by emergencies. If the governor of the state of Georgia declares a state of emergency, all unexpired deadlines are extended by the number of days of the state of emergency, but we capped that at 8 days. What's not clear is that 8 days per state of emergency, or is that 8 days total? In 2026, we've already had 2 snow days, and each one of them, the governor issued an 8-day state of emergency. So our unexpired deadlines um, now 16 days or 8 days? I don't have a good answer for you. My understanding was the purpose of this language change was this was a mid-year change last year. It was January 25 where we added the delay caused by emergency paragraph. It was the mid-year last year where we limited it to no more than 8 days. I don't have a clear answer. My thought was the intent was no matter how many state of emergencies we have, the most you can get is 8 days. Others have taken the position you get up to 8 days per state of emergency. No deadlines are extended if the agreement goes binding during a state of emergency. If you sign it on a snow day, however long that state of emergency exists, does not extend any deadlines. And this is the part where I tell you, congratulations on to 2026. Happy New Year. And I hope you found this 1 hour and 5 minute review of 2026 GAR contract changes to be helpful. Do you have any questions about any of the material that we've covered, or more generally, any questions about the GAR contract forms? If not, Faye asked if she could get a copy of the PowerPoint presentation, and I'm happy to share that. We record the Zoom presentation. We're going to clean it up, post it to our YouTube channel, and we'll link to it on our website. So you'll be able to go back and review the presentation. Then we send out a follow-up email to let you know that the video is available, and we'll include a copy of the presentation with that if you'd like to review it. Okay, thanks for the question, and I'm glad to help. Any other questions about either the material presented or more generally about the GAR forms? If not, on behalf of all of us at Schaefertz and Dean, thank you for giving us your time today. And we hope you've enjoyed our presentation, a quick 1 hour overview of important 2026 GAR form changes. And again, I took a 3 hour course and I tried to pull the most important parts out in a 1 hour overview for your benefit. Now, that said, I have one more CE class. It will be the first Thursday in March. I believe the date is March 5th. It will be in Dawsonville and also offered virtually. So if you would like to take the full 3 hour class and get the 3 hours of CE credit, I have one more opportunity coming to teach the CE class, and that's still an option to you if you'd like to go a little deeper into the material and get some CE credits. Diana, thank you for your kind words. I appreciate your kind words about our class today and the information being presented. We'll go ahead and close now and say I appreciate you joining us today, and I hope that one of my favorite quotes is from Kenny Rogers in his song The Gambler. I hope you found an ace that you can keep. I hope you've gotten some good information from our time together today, and we look forward to seeing you again, either in our future Business Builder Speaker Series presentations and also hopefully at the closing table in the future. Take care and thanks again.